Okay, so welcome everyone to week 6, and tonight we talk about legislative scope and purpose. So in last week's tutorial, we had talked about the principle of legality, and in particular we had said that when the actions of an executive have the capacity to infringe or interfere with the rights and freedoms of individuals, then there is a need for positive law that would authorize the executive action. When we speak of positive law, we said it has to be in the form of statute. In other words, a law passed by Parliament. This also tells us that although we know that the executive has certain constitutional executive powers based on Section 61 of the Australian Commonwealth Constitution, and we also know that the Commonwealth Executive has implied executive powers. More often than not, a lot of the activities of the executive, especially when they have an impact upon citizens, are actually authorized by statutes coming from the Commonwealth Parliament. And so this is in a way by which the Commonwealth Parliament determines what the national policy should be. So it's actually the Commonwealth Parliament that tells the executive what to do, so that in the end, ultimately, what the executive does is actually to enforce the laws determined and passed by the Commonwealth Parliament. So it's essentially the Commonwealth Parliament that determines national policy. Now, the question, however, is that oftentimes the laws passed by the Commonwealth Parliament, on the one hand, might not be too clear as to what the statutory purpose might be. And if that is so, the question that relevantly should be asked is, what would delimit the decisions made by the executive? Would it mean that if a law is unclear as to the purpose of the statute, or what if in fact a law has conflicting purposes? Like if you look at the Freedom of Information Act, on the one hand, the Freedom of Information Act Commonwealth talks about saying that government information that is possessed by government agencies are meant to be a public resource and should be freely available to citizens. But on the other hand, the Freedom of Information Act as well has made it clear that there will be certain information that should not be available to the public, such as deliberations by the cabinet, or it could be about security measures, national security measures, or activities conducted by the police. So there is a conflict there. We are also aware that there are several statutes which may run to multiple volumes, and therefore, when you go through these particular statutes, it could be about the Immigration Act, it could be about benefits that are given to citizens. After a while, it becomes unclear what the purpose of a statute really is. So in that particular case, what would then guide the executive in making a decision? At the same time, when the executive makes a decision, the executive is oftentimes required by a particular law to consider certain factors. So it could be, as far as determining whether or not to grant a visa to an applicant who wants to enter into Australia, who wants to remain permanently in Australia. The Immigration Act would enable the Minister of Immigration or his delegate to consider certain factors. Would it mean then that if there are, let's say, 20 or 30 factors in that particular legislation, would it mean that the decision maker is required to canvass and consider every single relevant factor? And what is the impact if a decision maker fails to consider all relevant factors? If there is a requirement as well that certain documents have to be submitted, and then it turns out that the decision maker failed to examine every single piece of document that was submitted, would that breach the mandate of the law? And what if at the same time, when an executive makes a determination on an application by a citizen, for example, the decision maker ends up considering certain irrelevant matters? Would that then vitiate the decision, and therefore, in that particular case, nullify or invalidate the decision? These are issues that we take up when we talk about legislative scope and purpose in week 6. So tonight, after studying this topic, you should be able to discuss and explain the 3 key rules that a decision maker must observe in making a decision or in exercising a statutory power. Namely, a decision maker must exercise a statutory power according to the purpose for which it was conferred. In exercising a statutory power, a decision maker must not take into account irrelevant considerations. And in exercising a statutory power, a decision maker must take relevant matters into account. Now, before we proceed, let me just greet you an advanced Merry Christmas, because we're just a few days away. So let me be one of the first to greet you a very Merry Christmas. Okay, so with that, before we proceed, would there be any questions that any of you may wish to raise? Any questions or comments? And then tonight, we will have 4 discussion questions, including going through the quiz question for the week. Questions so far? So we're good? Okay. So let's consider quiz 5. Can I just get a volunteer to read the quiz question for us? Just to read the question.
I can do it, Manjo.
Thank you, Sarah. Yes, go ahead, please.
Okay. The Higher Education Support Act 2003 Commonwealth, the Act, primarily provides for the Commonwealth to give financial support for higher education and certain vocational education and training through grants and other payments made largely to higher education providers in order to support the distinctive purposes of universities, such as the education of persons, enabling them to take a leadership role in the intellectual, cultural, economic, and social development of their communities, and the creation and advancement of knowledge. Under the Act, the Minister of Education, the Minister, may, at his discretion, impose guidelines as he sees fit in the pursuit and implementation of the objects of the Act. Concerned about the research and reports published by some Australian university academics that put countries such as China in a very bad light, the Minister, contrary to the authorised purpose under the Act, issued guidelines that university funding under the Act may be reduced when research and reports tended to or had the prospect of damaging international relations with another state. The Deputy Vice-Chancellor of an Australian university, the university, has come to you, a solicitor, for advice.
Can you go through as well, Sarah, the answers? Yes.
Sorry, yeah. I won't read the instructions. I'm sure everyone can read those. But A, the solicitor should advise the university against an application for judicial review concerning the minister's guidelines, since the university has no legal standing. B, the solicitor should advise the university against an application for judicial review, since the minister's exercise of discretion under the above facts is non-justiciable. C, the solicitor should advise the university to apply for judicial review, since the minister has exercised his powers under the Act for an unauthorised purpose. D, the solicitor should advise the university against applying for judicial review, since the minister has exercised his power under the Act for an authorised purpose. Or E, the solicitor should advise the university against applying for judicial review, since the exercise of his discretion is beyond the scope of judicial review.
Thank you. So can I just get all of you to provide an answer? Make a choice from A to E in the chat box. What do you think is the correct answer here? Okay. What do the others think? Okay, so generally the answer has been C. And okay, before I express my own opinion as to what the correct answer is, and so the class has predominantly chosen letter E as the correct answer, let's just examine the factual circumstances again. So we will notice that the Act provides broad powers to the to the minister, actually, to impose guidelines as he sees fit in the pursuit and implementation of the objects of the Act. So there is a broad discretion. And we know that as far as the primary purpose of the Act, because it says primarily, it also says that the primary purpose is, to foster the intellectual, cultural, economic development of communities and so on. Now, what the minister has done, and we admit under the facts that it is done contrary to the purpose of the Act, it was to issue guidelines which tended to, protect the relation of Australia with China, which in a sense is a very laudable purpose, isn't it? Because, China is a very important state and a strategic partner, perhaps, of Australia. So there is a lofty and even a noble purpose on the part of the executive in ensuring that China doesn't get upset by the research and publications by Australian executives. So those are part of the facts there. So having this in mind, what do you suppose is the correct answer here? Can somebody tell me why the answer is letter C? I did not say that your answer is wrong. I'm just trying to dig deep into the answers here.
Okay.
So from Kayla, because it is not consistent with the purpose of the Act.
That's fine.
So if the statute has been very clear as to what the purpose is, then it becomes an expression of the will of the Parliament on how the law should be implemented by the executive. The executive has little discretion to change the purpose or the policy behind a statute passed by the Commonwealth Parliament. So if the executive therefore decides to act in a manner that is contrary to the statute, the actions of an executive would be invalid. Now, what we need to remember is that as far as, we also said that in many cases, what the Commonwealth Parliament does is actually to delegate certain statutory power to the executive. And this is what is known as subordinate legislation. So in many cases, when it comes to policy decisions made by the executive, the policy decisions are more often than not based on regulations actually drafted and crafted by the executive. So it's not always based on the law. And you will see that there are policy guidelines coming from the executive as well. And in many cases. The point, however, is that, we discussed this, I think, in week 2, the moment a subordinate legislation, that's why it's called subordinate. If a subordinate legislation is contrary to the primary legislation, meaning the law passed by the Commonwealth Parliament, that subordinate legislation will be invalid. So it is the job of the Commonwealth Parliament to determine what the law is. It is the job of the executive to comply and implement and enforce the law passed by the Commonwealth Parliament. So the executive can only act in accordance with the statutory purpose. So even if the executive may have some noble motives behind his or her decision, if that decision is contrary to the purpose in the statute, that executive decision would still be invalid. So the executive is required by law to act only according to the authorized purpose of a primary legislation. So we're clear about this. Now, the other question we ask is, let's assume that the executive does act with the authorized purpose. But in doing so, what the executive did was actually to have an ulterior motive, a different motive in making a decision. So let's assume that the executive could have taken, decision A, or he could have taken decision B. And either way, the decision, would actually be authorized. But let's assume that there is an ulterior motive that is motivated by something that could potentially be unlawful, even if allowed by the statute. So, for example, it can be within the power of the executive to not to grant a visa because based on the exercise of discretion. It can also be within the power of the executive, obviously, to grant a visa to a visa applicant. But at the same time, it is possible for the executive to be motivated by, ill motives. It could be for political considerations. It could be for the purpose of hitting back, somebody who's trying to sponsor a particular visa applicant. But in that particular case, if we know that there is an ill motive, there is an ulterior motive that is behind the decision of the executive, even if it is an action that is authorized by the law. The question that arises is, can the decision of the executive, if it could be shown and it could be proven that it was motivated more by an ulterior motive, can that invalidate the decision of the executive, even if the decision was actually made in accordance with the purpose of a statute?
Yes, it can, as long as it's a dominating or actuating reason.
Very good. That's correct. So the fact alone that the actions of the executive may actually be authorized by a statute, if there is actually an ulterior motive that becomes the dominating or actuating force behind the decision, that particular decision can be invalidated. So are we clear there? It has to be done with the proper intention. So if there is an ulterior motive behind it, that will invalidate the executive decision. Okay, very good. So we have the answer there. From Nicholas, it says no. Nicholas? I kind of missed the time when you said no here, so I'm not too sure which part of what I had said or which part of the discussion you might have referred to. Nicholas, would you like to say something?
Yeah, I was just in relation to that last point. I was going to say no, it wasn't going to happen unless, and then Sarah jumped in and said the reasons why. So
okay.
It's the same answer with a different spin.
Okay, very good. Okay, thank you. So let's go through discussion question 1. Can somebody go through, can somebody read discussion question 1 for us? Maybe Nicholas, do you think you could do it for us, please?
Yeah, I can do that. Okay, the Commonwealth Development Authority Act, Commonwealth, authorised the Commonwealth Development Authority, or CDA, to compulsorily purchase and acquire any land necessary to meet the infrastructure needs for new roads and highways of the Commonwealth. At the CDA's Executive Committee meeting on the 16th of May 2013, the CDA's Chief Executive Officer proposed the purchase of a sizable property along Benwick Road that was close to an area where a multi-billion-dollar commercial complex was being developed. He noted that the Benwick Road property is likely to appreciate in value as a result of the commercial development going on in the area. The proposal was approved by the CDA Executive Committee. In June 2013, Greg Harrison received a letter from the CDA stating that it was commencing negotiations with him for the purchase and acquisition of his property along Benwick Road, as authorised by the Commonwealth Development Authority Act. Greg does not wish to sell his property and has come to you as a solicitor for advice. He's brought with him a copy of the 16th May 2013 Executive Committee meeting of the CDA. Advise Greg whether there are strong legal grounds to oppose the CDA's offer to purchase.
Very good. Thank you. Can I ask you, all of you, if you could, to put in the chat box what you think is the correct answer? Is there a ground to oppose? Yes, there are grounds to oppose, or no, there is no strong ground to oppose. Yes, there are strong grounds to oppose, or is it a no? So from Keela, absolutely, there are grounds to oppose, yes. From Sard, yes, depending on further facts. From Keith, yes, it was not approved for the right purpose. Okay, so very good. Can somebody try to provide an answer here? So it's a good thing, we're quite clear. So again, we notice that even if an executive, okay, I'm not going to jump into it yet. Can I just get somebody to provide an answer before I jump in?
Manjo, I'll give it a shot.
Thank you, Travis.
From my understanding, that even though the Commonwealth Development Authority Act authorises the compulsory purchase of land, it's intended for the purpose of new roads and highways and other infrastructure, not for conducting for-profit exercises.
Very good. Go on.
Well, since then they've used that compulsory acquisition power for something not authorised or intended by the Act.
Very good. So that's correct. From Michael, similar to some rain versus Metro Water and Bandura Enterprises versus WAPC, there are strong High Court precedents, and what the precedent really is that any action on the part of the executive must be according to the authorized purpose of the Act. So even if you might say that there is a laudable purpose behind the decision of the CDA Executive Committee to try to acquire this property for the purpose of investment, because imagine if it becomes successful, that speculative venture can reap billions of dollars, which can then be used to purchase roads. But that is not an authorized purpose under the Act. So the rule then clearly is that the executive must act according to the purpose of the statute. If the executive acts contrary to that which is authorized by the statute, that act would be ultra vires of the Act and therefore invalid. Notwithstanding the fact, as I said, that there is a laudable purpose. So even if the motives are good, the fact alone that the actions of the executive are contrary to the purpose of the statute.
Manjo, can I just clarify something there? Because I remember reading today, I'm sure, about an issue where a particular water board went to buy a parcel of land and they were going to put buildings on it to expand the amount of people they could have working for the water board. But at the same time, they were going to make a stack of cash by buying this land and going into a joint development. That's true. I think because they had a dual purpose, the judgment came down in their favour only because they could prove that the building was the bigger part of the action that they were taking rather than the making money off the land with the joint venture.
That is correct. You nailed it there. That's correct. And so you notice that when the actions of the executive at that time were made, you will notice that on the one hand there was possibly a desire to make it an investment, but there was also on the other hand a desire to comply with the requirements of the law, which was to build buildings for the waterworks company. But because the main motivation was really to build buildings in compliance with the law, and there was only a secondary purpose in the process by which the investment could pay good dividends for the company, that because the main purpose was really in compliance with that authorized by the law, then the executive decision was declared to be valid.
You've got to wonder, though, in those cases, Manjo, how many times they make it look like the main purpose is X on paper, when in reality their purpose is Y in the background, and that's what they're really working on.
That's true. That's really true. That's really true. Now, what we also need to remember is that if an applicant seeks to attack a decision made by the executive with the allegation that the decision of the executive is actually unauthorized, or it is unauthorized mainly because it is driven by an ulterior motive, and the ulterior motive is actually the dominating or the actuating force behind the decision, the burden of proof to allege that the decision is for an unauthorized purpose lies with the applicant. It is not for the executive to show that that the decision was actually according to what the law says. There is a presumption that the executive acted in good faith.
Pretty hard for the applicant to prove in some of those cases. Because I would imagine that if they're putting forward X, but their real ultimatum is Y, that object Y, they're not going to publish that. They're not going to tell a lot of people. They're going to keep all the information in a close inner circle, just like most government departments do, as we know.
That's true. In fact, Travis was saying, subpoena certain documents. But what has really happened, and we read this in the textbook and we read it in the newspapers now, is that when the executive, especially when they have an executive committee meeting, in many cases, the decisions by the executive are no longer put in the minutes of the meeting. They hide them because there is the Freedom of Information Act, as pointed out by Keith here. So any minute, if there is a minutes of the meeting that becomes public property, and every citizen has the right to seek access to the minutes of a meeting, and it is for this reason that in many cases deliberations by executive agencies are oftentimes not recorded in writing, in order to insulate the decision makers from potential trouble, from potential legal trouble, who could then question what exactly. So, because if you go through the minutes of a meeting, there would be a lot of discussions about pros and cons, right? There'll be arguments in favor of this or in favor of that. And if you had a transcript or you have minutes of the meeting that actually put in detail all the discussions and the arguments, it would then be possible for someone to argue that the main reason why a decision was adopted was actually a reason that was not allowed by the statute. So in many cases, therefore, what then would happen is that you end up just with, the main decision and perhaps the reason agreed upon, but a lot of the discussion would no longer be there, precisely to shield the decision makers from the possibility that somebody would rely on the Freedom of Information Act in order to ensure that vital information is then made open to the public, and which could then be potentially used to overturn a decision made by the executive. So it is a difficult task, Nicholas, as you correctly pointed out.
Yeah, I was gonna say, Manjo, a lot of these cases you can read them where they happen, and somebody's land has been subsumed, and then it may be 20 years or 30 years later until somebody dies that set up this conundrum, and somebody decides to finally put their hand up and tell the truth, but it's too late. That family or that business is gone. They've lost everything. And the other issue we're having now politically is in Hansard, they're not even reporting what's being said in the parliament. And that's a big issue as well. So what do we do as individuals to ensure that the government is doing what they're supposed to do? Because we don't have an ICAC at the federal level. Do we need one?
That's a good point. That's a good point. Yeah. Okay. We will leave it to the maybe to the politicians and to the actively minded citizens to have a discussion about that. Yeah. So as pointed out by David here, bigger issue is public service, and culture and values. But that is the whole point. On the one hand, when we discuss Freedom of Information Act in week 11, on the one hand, there is a desire to arm the citizenry with information, because an informed public is in a better position to assist the government in making decisions, is in a better position to elect public officials that will be able to pursue the policies that are desired by the nation. But on the other hand, there is a countervailing purpose as well of the Freedom of Information Act to protect vital information. So not everything really is available as a public resource to the public. When you look at the Freedom of Information Act, certain information are still not within the pale of public scrutiny. It could be for national security issues. It could be because of police measures. It could be because of budget discussions, which are considered to be sensitive. It could be because of certain commercial applications, which are deemed to be sensitive. So there is often that conflict in terms of the values. So on the one hand, as pointed by David, you can talk about public service, but on the other hand, again, there is a need we see this in the Freedom of Information Act discussion, there is a need to allow government officials a certain level of candor and openness that, that is not really subject to scrutiny by the public. Because otherwise, if a government official is aware that anything he says can be reported in the media or could really be subject to public scrutiny, then in all likelihood, an executive might be really unwilling to be very honest and open about his own views. So the government realizes that. So there is a level at which public scrutiny is not permitted of certain, public information.
Yeah, I only pose these questions, Manjo, not because I believe one way or another, but to get to think, make people realize that there is two sides and they should be looking at both sides of the equation, not just what's put in front of them.
That's true. That's true.
Yeah, and Manjo, all these acquisitions, they have to be within a town planning scheme. They just can't say we want that piece of land now. So
that's right.
So that's one of the big points about it. So it is quite easy to identify what's happened there.
You're right. You're right. Okay. Very good. So let's move on to discussion question 2. Can I ask somebody to read discussion question 2 for us?
Must be Michael's turn by now, I think.
Michael, if you could, would that be all right? You have been volunteered by Nicholas.
Thanks, Nick. Yeah, I knew I spoke for a long time, didn't I? All right, let's see how I go. Under the National Business Risk Assessment Agency Act 2012, Commonwealth, the National Business Risk Assessment Agency was created to examine, review and assess business risks to Australia and provide policy recommendations in the area of business risks to the federal government. The Act also empowered the NBRAA to review its statutory mandate, broaden the scope of its purpose, and make every regulation necessary or convenient to be prescribed for carrying out or giving effect to this Act. In May 2013, the NBRAA Executive Board, concerned with human rights violations and security threats in Afghanistan, Iraq and Syria, passed the Restricted Commercial and Business Activities Regulation 2013, which imposed huge fines on any Australian business that conducted or engaged in any new business or commercial activity in any of those countries without its prior written authority. The Hotbed Startup Proprietary Limited sought approval from the NBRAA to sell its products in Syria. When the NBRAA refused to give its approval, the company challenged the agency's legal authority to pass the Restricted Commercial and Business Activities Regulation 2013. In its letter to the company, the NBRAA pointed out that under the National Business Risk Assessment Agency Act, it had broad and unqualified powers to validly pass the contested regulations. Hotbed Startup Proprietary Limited approached you as a solicitor for advice. Advise the company whether it has a legal ground to challenge the decision of the NBRAA. And you just deleted something.
That's it.
Okay.
Thank you.
Tongue twister.
So what do you think? Is there a legal ground to challenge the decision of the NBRAA?
I'm going to say no, because that's coming back to that ASIS or ASIO, or not ASIO, ASIS grounds, because political and strategic reasons. So I'd say you can't review that one.
Okay. So you're talking of non-justiciability here, is that it?
Say again?
Are you talking of the principle of non-justiciability, that this involves a political decision and is not subject to judicial review?
I'm talking about not being subject to because of national security.
Okay. Very good. Just on that point, what do the others think? If the executive says that the decision is made on the basis of grounds of national security, does it then necessarily mean that that executive decision is beyond judicial review?
No. They've got to be able to show that it's in line with another law and the Constitution to be able to do that first.
Very good. So that's correct, Nicola. So if we examine A versus Hayden number 2, which we examined last week, the executive cannot just claim that it is, an act done for the purpose of national security. The executive and even the parliament, as pointed out correctly by Nicholas, must still comply mainly with the Constitution. So the national security is not a trump card that enables the executive to just do what it wants, or even enables the Commonwealth Parliament to decide to come up with a law on any subject. Any act, any law passed by the Commonwealth Parliament must still be in accordance with the Australian Commonwealth Constitution, and certainly any actions on the part of the executive must also comply with the law and the Constitution. And it is always open to the executive, open to the judiciary in an application for judicial review to examine the legality of executive decisions. Now, in many cases, when the executive says that it is making a decision on the ground of national security, if there is a strong political consideration behind the executive decision, and if the executive decision relies mainly on a national policy consideration, then in that particular case, the executive are unlikely to make a decision against the executive decision. But it is always the duty of the judiciary to examine whether the actions of the executive are according to the law. From Keith here.
I was just going to ask that same question, Manjo, because Keith poses a really good question, and we know if these laws are created that depends on the rights of an individual, then it can be challenged. But when we're looking at a company in this instance, a company can be seen as an individual too under the law. So if the law that's created only affects an individual company, can it also not be challenged judicially?
Okay. So,
but aren't the rights in relation to restrictions on freedom and basic human rights, aren't those the rights that we're talking about? We're not talking about, I don't think so. I don't think a company would constitute an individual in this case.
Well, what is really crucial here when you examine a discussion problem like this is really to focus on the legal issue. At this point, there's really even no need to talk about human rights or even political rights, or whether or not companies have certain human rights. The relevant question for us for discussion, question 2, is whether or not the decision made by the NBRAA is actually according to the law. That is the relevant question. And so there are two aspects to this. The first point is that when you examine the enactment, the purpose of the enactment in creating the NBRAA was for the NBRAA to examine, review, and assess business risks to Australia and provide policy recommendations. Now we notice as well that that particular act does say that it may broaden the scope of its purpose. Now the question is, in relation to that particular point, that the NBRAA has the power to broaden the scope of its purpose, would it mean then that that is a blanket authority on the part of the NBRAA to broaden the scope of its purpose, whatever way it likes? So
no, it still has to be in line with the Constitution, no matter what broad purposes it seeks to impose.
That's right. But more than that, it has to be in line with the act that created the agency. And you will notice here that the act was focusing on business risks. So in other words, if the agency, using the discretion given by the act, then decides to consider political risks or risks to human rights, that would no longer be within the scope of the authorized purpose under the Act and would therefore be invalid. So are we clear about that? Now, at the same time, and I think we're considering this at some point, I wonder. You will also notice here that in this particular example that I made, the NBRAA also imposed huge fines. And, does somebody notice anything in relation to the imposition of huge fines versus the powers given to the NBRAA concerning the imposition of fines?
They don't have the authority to do that, isn't
They don't
that?
have the authority as well.
They do have the authority, or they don't? I thought they did.
They don't have the authority for that. So that would again be ultra vires. So in other words, the mere fact alone that the executive seems to be making a decision, as lawyers or as future lawyers, we always have to wonder, does the executive actually have the power, to do what it wants to do? You always have to ask that. Is the executive decision authorized by a statute? Or even if the executive decision, for example, is authorized by a regulation, by an executive regulation, the question then is, would the regulations passed by the executive be consistent with the main legislation that authorized the making of the regulation? So these are relevant questions that always need to be asked.
So just to clarify here, we're making sure that the regulation is in line with the what the executive has put down in the Act, and
Yes.
the Act itself has to then still be in line with what is legal within the Australian Constitution.
Very good.
Right.
That's right.
'Cause, Manjo, just
Yes,
the
Jay.
way that they broaden the scope of the purpose is worded is actually rather alarming. It's almost like a blank check, isn't it?
Yeah.
So essentially, we're opposing the legality of the actual legislation, aren't we?
Yeah. So even if the statute itself is worded in such a way that it seems to give unbridled power to the executive to broaden its scope, it's not really unbridled power. It still has to be in accordance with the main purpose of the statute. So do not be deceived by the fact alone that the language of the statute seems to provide a very unlimited power to the executive to do what it likes. That can never happen.
That's where our ability to understand statutory interpretation comes in then, isn't it?
That's correct. And we will recall that even in those instances when a statute may provide that the executive has absolute discretion to satisfy itself, it doesn't mean that just because the discretion is absolute, no one can then question the exercise of the discretion. If the exercise of the discretion amounts to what is known as unreasonableness and reasonableness, we know that will be unlawful. If we know that even if the discretion is absolute, if we know that if the exercise of the discretion is not backed by evidence, in other words, if there is no evidence supporting the decision, that decision can still be unlawful. So in other words, what it tells us is that we should not be deceived by the very broad language that potential is within a statute. It only means that any broad language used in a statute must still be understood in the context of the purpose of the Act. And in fact, assuming that the Act itself is silent, what then happens when the Act is silent as to the purpose? Because it's possible for an Act or a statute not to indicate what its main purpose is. What then happens? So what happens? So my question was, we said that the executive must act in accordance with the statutory purpose. But what if the statute is silent as to its purpose? Or what if the statute has multiple purposes and there are conflicts in the purposes of the statute, such as the Freedom of Information Act? What then?
I think as Keith said, you've got to look at the whole statute, and they tend to read it as a whole to try and get the the main gist of it and identify the leading provisions and then go through those?
Very good. That's good. That's correctly pointed out by Sarah and by Keith there. You have to view the whole statute to discern the purpose. You will normally be able to figure out what the purpose of the statute is. You normally will be able to do that. Or at least that is the job of judicial interpretation. They will seek to determine what exactly is the purpose of the statute. And that can be determined also by looking at the debates in the Commonwealth Parliament in order for us to know what was the motivation behind particular statutes. And in the event that there is an inconsistency among the purposes, as pointed out by Sarah, it will be part of the task of statutory interpretation to determine which are the leading provisions, which are the most important provisions, and with a goal always to try to harmonize, if at all possible, statutory provisions in order to be...
Sorry, Manjo, I was going to say it'd be nice if statutes in general, their titles were expressive of what they're about, but it is very rare that the title of a statute actually explains anything about it, if not like the freedom of information. It doesn't mean that there's freedom of information, as we know, along with many other statutes. Their title almost has nothing to do with what's contained in the actual statute itself.
That's true. That's true. Yeah. From Travis, look at the U.S. Patriot Act. Yeah. Okay. So we've got another discussion question here. We've got another one. Okay.
Must be Travis's turn this time, I think, Manjo.
Maybe we could just jump to discussion.
I'll give everyone a go. Get them all in for once.
Let's go to discussion question 4 first, and then we'll try to get back to discussion question 3, because I think this is as important here. We might run out of time.
I've been called out. The Aboriginal and Torres Strait Islander Heritage Protection Act of 1984 Commonwealth, the Act, conferred the power upon the Minister for Aboriginal and Torres Strait Islander Affairs to make a declaration in the area in an area that is significant, that is a significant Aboriginal area under threat or injury or desecration. The Act required that the Minister must give due consideration to a report that should be prepared in relation to an area that is a significant Aboriginal area and may be under threat, injury or desecration. Company X applied for permission to build a bridge on an Aboriginal area. Following the Act, a report which included over 400 submissions was prepared thereon by Professor Saunders. The Minister issued a declaration that the subject area was not under threat, injury or desecration. P has approached you, a solicitor, for legal advice whether the Minister's decision can be quashed, set aside an application for judicial review. P has evidence that the Minister has not read all 400 submissions, but has relied on a summary of submissions. Provide legal advice.
Thank you. So the legal issue really here, what do you think is the legal issue here? What is the legal issue? Okay, so Michael has said the decision maker must take relevant matters into account. Okay, that's good. It's a good starting point. It's a bit too broad though. What is the legal issue? Because it could be said in the particular case, the decision maker did take relevant matters into account. The question is the decision maker required to read and consider all 400 submissions? That is the legal issue there. Do you suppose that the minister is, if there have been 400 submissions, is the minister required to read all the 400 submissions? And so therefore, could he rely on the summary? The answer is yes. There is no requirement. There is no requirement on the part of the executive to read all submissions in their entirety. Because as pointed out by Michael, there could be 40,000. And from Keith, whether looking at a summary of submissions is sufficient to satisfy the requirement to give due consideration. So that's a good point as well, because the requirement here is that due consideration must be given by the minister. And if the minister has given due consideration by relying on a summary, then he is therefore compliant with the requirements of the law, unless the law is very specific that says that the minister is required to consider every single submission, and probably with the added requirement that the minister must read through every single submission. Then only in that case can it be said that the minister will have a duty to read all the 400 submissions. There is a related point, and the related point is that sometimes when an executive decision maker is required to make a decision, there are multiple factors that the executive decision maker might be asked to consider, with emphasis on might. Or it could be that the minister shall consider, the word might be shall consider. In that particular case, if let us say that there are 15 or 20 factors that an executive has to consider, will it mean that the decision of the executive, number one, must clearly show that due consideration was made to every single factor in the statute? Is there a requirement or not? In other words, and is there a requirement in particular for the minister to actually consider every single factor, so that the failure of a minister to consider one factor among multiple factors will vitiate the decision of the executive?
Yeah, that's one area I wasn't quite sure on, Manjo, and I've been trying to ponder that and reading over it. I didn't think it was that he had to take in every individual decision unless it was written in the actual legislation specifically that he had to do X, Y, and Z. If that was the case, then he has to follow them.
That's correct. So as pointed out by Keith here, there is no such requirement. That is correct. Unless the statute specifically provides that the executive must consider every single factor or every single consideration as stated in a statute, there is no requirement on the part of the executive to consider every single factor. And the failure of the executive, therefore, to consider one factor or even several factors out of many will not invalidate the decision of the executive. That's correct. From Michael, the task would be too onerous to do so. Okay, any questions so far? So we're good. So finally, can we have a go at discussion question 3?
Come on, Keith. You can do it, mate.
Can somebody volunteer to read? Okay.
I'll volunteer. Good. P, who had just completed her 4th form school year on 26 November 76, visited the Commonwealth Employment Service in order to ask about her entitlement to unemployment benefits. Under the Social Services Act 1947, Commonwealth, in brackets the Act, a person shall be qualified to receive an unemployment benefit when he satisfies the Director General, DG, that he has met certain conditions under Section 107, paragraph C of the Act. Under the Act, a school leaver could be entitled to unemployment benefits from the time of completing 4th form school and up to the end of the long school vacation, for as long as certain conditions under Section 107, paragraph C of the Act were met. However, the DG issued a policy which effectively disqualified all school leavers from being eligible for unemployment benefit from the end of the school year up to the end of the long school vacation. Following the DG's policy, the CES informed P that she could not, as a school leaver, be considered for unemployment benefits under the Act until after the end of the long vacation. P has come to you, a solicitor, for legal advice. How does an unemployed school leaver get the money to pay a solicitor? What advice would you give her?
Okay. what is the situation here? What is the legal issue? So we can see here that what the Director General has done was actually to make a requirement that the benefits can only be subject up to the end of the long school vacation, when in fact, according to who's that? Hang on. I may have been wrong when I wrote this. Give me a second.
Yeah, so it's under the Social Securities Act 1947. A person on unemployment could claim unemployment between leaving school and the end of the school vacation, but the Director General has now instigated something to prevent that from happening.
So it's from the end of the school year, when in fact there is no requirement that it should be from the end of the school year. Okay, so it's from the time of completing fourth form. So in other words, what the Director General has done is to shorten the period for a school leaver to be able to receive particular benefits under the Act, when in fact under the Act it's possible for a school leaver to have a longer period of time during which to claim benefits, because it doesn't have to be at the end of the school year, because a school leaver can actually end up leaving school prior to the end of the school year. The question is, what then happens? Would it be, would the Director General have the power to pass this regulation?
I thought what the DG was saying was when you left school, you couldn't apply for the benefit until after the school vacation had finished, whereas before they could apply immediately upon finishing school.
So what he's done is effectively made it impossible for anybody to satisfy him that they have met certain conditions, whatever they are, under Section 107, Paragraph C of the Act.
That's right. So what exactly is the legal issue here? What is the legal issue?
Is it that the policy is actually contrary to the main act?
That's right. So the legal issue is, does the executive have the power to pass regulations that are contrary to the main act or the primary legislation? The answer is no.
So it's ultra vires, is that what we're saying?
It will be ultra vires. Again, any regulations passed by the executive must be in accordance with the primary legislation. Otherwise, any such action on the part of the executive would be invalid for being ultra vires.
All right, whatever you do, Manjo, don't give us a question like the one we're looking at for the end of term, all right? You're going to confuse too many people. I'm just making that clear right now.
Okay.
What's fourth form for a non-Queenslander?
Can somebody answer that?
Year 12, mate.
Okay, what, there's only 4 in Queensland? It's only 4 years, not 5?
Yeah, no, because yeah, they do 1 to 6 in primary school, and then year 7 is the first year of high school now.
Okay.
It used to actually start being renumbered in high school. So you did first, second, third, fourth year. At the end of fourth year, you did what's called the school certificate. Then you did fifth and sixth year, which is now years 11 and 12, and that was the HSC.
Ah, so it's in essence year 10 or something. Okay.
Okay.
Yeah, year 10.
Cool. Yeah.
Okay. Any questions before we end tonight's session? So we're good?
Yeah, I'll ask one, Manjo, just for those people who don't read and probably haven't checked the notice boards and done everything else. When are the midterm exam results coming back? Not for me. I know when they're coming back.
On the first week of January, based on the unit profile. I can't really remember. A lot of papers for me to mark over the Christmas break, actually, because I'm marking administrative law. There are about 130 papers that are submitted, and they have another 70 for public international law. So there's a lot of markings to be done during the Christmas holidays for me. But I'm going to get them done on time. We're going to have to check the unit profile. I can't remember the exact dates.
That's all right. I'm not concerned. And Merry Christmas to you, Manjo.
Merry Christmas, everyone. And thank you again for being here at tonight's session. See you soon and have a lovely Merry Christmas. Bye.